May I please, Your Lordship? Your Lordship, I beg to mention item number 1, Your Lordship. I have taken the consent of the petitioner, Your Lordship. May it be fixed after 3 weeks?
After 2 weeks.
3 weeks, Your Lordship.
3 weeks. With consent of the other side, Mr. Vadi Ram and Government Advocate pays for adjournment. Prayer is allowed. List after 3 weeks.
Obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 2 and 4. I'm on behalf of the petitioner. The matter may be listed after 3 weeks.
2 and 4.
2 and 4.
In 2, there is a private respondent. You have taken his consent.
Yes, I have taken consent, yes.
What says the representative on the prayer made by Land Council for the petitioner? List after 2 weeks.
Yes.
Okay.
3 weeks, yeah.
3 weeks.
3.
Okay. 2 and 4. Okay.
Much obliged.
May I, Your Lordship? Lordship, I beg to mention item number 7. Here, we are yet to receive our para-wise reply for filing our counter affidavit. At least 2 weeks' time may be granted, Your Lordship.
Which is the department who is to give you instructions?
Yes, sir.
Just see item number 7.
Sorry. मोदी भैया होगा नहीं।
Okay. With consent of the other side, SP Pangut and a government advocate pays for adjournment. She is awaiting further instructions. But 1 to 4 has already filed an affidavit. That's why.
Union of India.
Achha, you are
Yeah,
Union of
filed.
India. Okay.
I am for 5, 6, and 7, Your Lordship.
Preparing the state respondents 5 to 7. Next paragraph. As the petitioners have alleged that their private land has been in illegal occupation of the respondents, comma, the Deputy Commissioner, Shiomi District, within bracket respondent number 5, and the Director Land Management, within bracket respondent number 7, shall ensure that appropriate instructions are received by the Office of the Senior Government Advocate within the extended time allowed, during which the matter would be heard on the basis of materials available on record. Next para, the learned government advocate shall send a downloaded copy of this order to the said respondents. Next para, list on, give date after 3 weeks.
Obliged, Your Lordship.
May I please, Your Lordship?
24th July.
I wish to mention item number 11, Your Lordship, wherein the state has filed their affidavit in opposition, Your Lordship. So I take your leave, Lordship, to file affidavit in reply against the affidavit of opposition. For that reason, Your Lordship, 2 weeks.
As a represented on the prayer made by Land Council for the petitioner,
11.
list after 2 weeks so as to enable the petitioner to file affidavit in reply in the matter.
I have informed the other side also.
May I please, Lordship? I beg to mention item number 16 and 17. On the request made by the Senior Counsel for the petitioner P.K. Tiwari, Lordship, let the matter be fixed on 22nd of June.
This is a very old matter.
Yes, may I, Lordship? Lordship, I on behalf of respondent number, private respondent,
6 and 7, Lordship. Lordship, at this matter, Lordship, my senior have some personal difficulties on 22, Lordship. List any other date, Lordship, appropriate date, Lordship.
Give a date after that.
29,
What
29.
pleasure presented
29.
on the prayer made by land council for the petitioner. The matter stands adjourned today. List on
29 June.
29 June. 29th, it will not be, it will be just very near to the vacations.
Yes, Lordship.
Then
Lordship,
22nd July.
Lordship.
22nd July.
Yes, Lordship.
22nd July.
Much
Much
obliged.
Item number 3.
What has happened to the tender and contract? None appears on call for the petitioner. However,
Ms. Ojala, Your Lordship, appearing on behalf of DSJM Kato for responding, Your Lordship.
on behalf of standing counsel for
No, sir, no, Your Lordship. DSJ for Union of India, Your Lordship.
DSGI.
Yes, Your Lordship.
Okay, on behalf of on behalf of DSGI. Next paragraph. Appears that pursuant to the notice of termination, pursuant to termination order dated 25/10/2024, comma, the contract in respect of construction of page 127, construction of 4 numbers of so and so, was retendered. This code by an order dated 5/11/2024, passed in WPC 504 of 2024, issued a direction, interim direction that till returnable date, no coercive action shall be taken against the petitioner pursuant to termination order dated 25/10/2024. Thereafter, comma, a fresh tender has been issued for the same work. Which has been challenged in this writ petition. Next, it is noticed that in respect of the contract work which was terminated, the contract agreement contains arbitration clause as well as provision for conciliation. Under Article 26 thereof. Therefore, it appears that there is no impediment for the petitioner to avail the alternative remedy as provided for in the contract agreement that was terminated by order dated 25/10/2024. Let's start. Next, it is also observed that there is no interim order operating in this writ petition. Next, for injured justice, as the petitioner remains absent on call for injured justice, the matter stands adjourned today. Next, it is made clear that if the petitioner remains absent on the next date of listing, adverse orders would follow. Okay,
Much obliged.
just after,
After,
wait, after vacation.
after vacation.
22nd July. Item number 5.
Much obliged, Your Lordship.
May I please, Your Honor?
Yes.
Your Honor, I am appearing for respondent number 4, my lord, private respondent. My lord, affidavit in opposition from my side has not yet been filed, my lord. So I may be,
That is good. We'll have to read less. We welcome it.
yes,
We
my lord.
now don't have to read it if you have not filed it.
I may be granted some more time, my lord.
Okay, how much time?
2 weeks, my lord.
Okay. All sides are represented. On the prayer made by Land Council correspond before 2 weeks. Time is granted to file affidavit in opposition in the matter. What has happened to the inquiry in the meantime? What has happened to the inquiry? Is it over? No.
No,
Still continuing.
still continue. Except for constituting that inquiry committee, nothing has been done.
This for the state, what has happened? Why you are not? Why the inquiry is not going on? Yes, Mr. Tapin.
If so far that part is concerned, Lordship, I have discussed with the department, Lordship, and I've sought for Lordship terabytes. Upgraded one, Lordship. The additional terabytes.
You see, if you are saying that the DPC minutes is doctored, how much time does it take to make the inquiry?
Your Lordship, may I, Your Lordship permits, if we file our affidavit, bring on record several things. There have been several litigations between these two parties. In fact, one
No,
case, in all along, my lord, all along the DPC, my lord, by which our services were regularized, were placed on record. All along, my lord, from 2008 onwards, there has been litigation. It's still going on. Now is this exclamation afterthought. Well, let's bring everything on record, man. There have been several litigations. Even now, 2 pending here, 1 pending in the Supreme Court also.
Supreme
All of
Court
a
is-
sudden now,
Supreme Court is closed.
Close.
Supreme Court is closed.
there was they filed a review. I was not aware of that.
Okay, review, we are
So
not aware.
after that, my lord, this has come. So I will bring everything on record from the very beginning, my lord, there was litigation between us. All along the minutes of the DPC, my lord, that by which we were regularized, my lord, that was placed on record, including by us, the state, as well as by the petitioner. Now I don't know why, how they have come up with this, my lord.
Mr. Kapil, it's a failure of administration. If your records.
Yes, yes,
say that-
absolutely, my lord. All these years, my lord, one thing was being relied upon. Now, I don't know who has done it, but
Mistakes at the government level are at times procured. Somebody is desiring to stall everything.
it appears
And will give the instructions as to the DPC, what has happened to that, sorry, inquiry,
Inquiry, I'll
by what time? And will give the instructions to you.
Lordship, 1 week, Lordship. On that aspect, Lordship.
Hmm?
On that particular issue, Lordship.
Yes, who will give you instructions?
Uh,
records has to be,
Lordship,
The Commissioner, Department of Urban Affairs.
yes, secretary or the commissioner.
R2, Lordship.
Okay, all sides are represented. Mr. D. Panging, Learned Counsel, Learned Senior Counsel, assisted by
M. Doji,
Ms. M.
M. Doji.
Dodi, Learned Counsel for the respondent number 4. Praise for is granted 2 weeks' time to file affidavit in opposition in the matter. Next para.
They try to have to tell you all the truth.
It is, in this case, the case projected by the petitioner is that a fact-finding inquiry was constituted on 15/5/2021, but the same did not make any progress. Full stop. This full stop on a query, Committee Learned Counsel for the petitioner as well as the Learned Senior Counsel for respondent number 4 have submitted that there are a series of litigations between the petitioner and the respondent number 4. And that all of a sudden a new stand has been taken by the state respondents that the previous DPC minutes were doctored. Full stop. Next paragraph. This, the state submissions show a very sorry state of affairs in the Department of Urban Affairs. First of all, it appears that for the purpose of full stop. Therefore, comma, the court is inclined to direct the Commissioner to the Government of Arunachal Pradesh, Department of Urban Affairs, within bracket respond number 2, to file an affidavit to inform the court as to within what time the said authority envisages the inquiry to be completed. First off, it is made clear that if no affidavit is filed, the matter would be heard on the basis of materials otherwise available on record. Next paragraph. On the next date of listing, the learned counsel for the petitioner as well as the learned senior counsel for the respondent number 4 as well as the learned government advocate shall provide the list of dates and bullet point of their respective cases. Next paragraph. The affidavit of respondent number 4 shall be filed within, give a date after 2 weeks.
2 weeks. 1st July?
No, it will not be stated now. 1st July. First of affidavit in reply, if any, by the petitioner shall be filed within a week thereafter, i.e. by within 20/7/2026. First of this is the matter for further consideration on 24/6, so 24/7/2026.
Another interesting aspect, my lord, is that by the order by which I was regularized, there were 3 other persons with me. But your lordship will say, oh, I'm the only party here. Only I have been made party here. The dispute has been between us, that is why. By the same order, 4 persons were regularized, madam.
You know, there are many, many great stars, but we remember few of them like Sylvester Stallone, like.
This is, my lord, this is something happening in our state, my lord. In fact,
That's okay, but we tend to remember only few of them.
Yes. Oh, my God.
Many stars.
Item number 6.
I'm appearing for respondent number 7 to 11. We have raised the question of maintainability, although
Maintainability we may not take up even if there is a good ground. The reason is that so many affidavits have been filed. At least there are 17 exchanges of petitions and affidavits.
Yes.
No, whatever but it becomes very difficult. It takes us the same effort by which we can dispose of the writ petition itself.
But this is raises the disputed question of facts.
That also can be considered when we take up the matter on merit.
But all the respondents have raised the plea of maintainability of the writ petition, not only on the locus, but also, my lord, with regard to the prayer made therein. Pleadings are complete, so I pray, my lord, that matter will be fixed for disposal, my lord. The entire maintainability as well as my lord, writ petition can be disposed of. I am appearing for the respondent number 17 to 26.
But you see, Mr. Saikia, the issue relates, one of the prayers is with regard to the cancellation of APSC certificates. You should go to the caste scrutiny committee. That is the law laid down by the Supreme Court.
Yes, my lord. They themselves has admitted that they have submitted representation before this committee.
What is happening? Why the committee is not functioning here?
It's functioning, my lord.
So far as, my lord, the judgment of Madhuri Patil case is concerned, my lord, that has been Subsequent judgments of the my lord, Supreme Court has clarified that that is operable where there is no rule, etc. my lord, rule, regulation, etc. That has been clarified. Now here in the instant case, there is admittedly my lord, regulation is there, which is a my lord, gazette notified, and they have challenged that also. Now we have another notification of the my lord, Guwahati High Court, which says any act and rules, if need to be challenged, it will be before the division bench. First of all, the prayer number 1, my lord, the prayer is at page 37.
No, that would not be applicable because here they have only challenged the guidelines. Guidelines is not we don't understand the guidelines to be a rule or a provision of the act.
In absence of my lord, the rules, my lord, this is a gazette notified, my lord, guidelines.
No, maybe gazette notified, but still doesn't fall within the definition of rules or act which is to be taken up before the division bench.
Then, my lord, the third challenge, my lord, he is challenging the, so far as I am concerned, my lord, my clients are concerned, they all belong to my lord Monpat tribe, my lord.
Yes,
Now,
that's why
none
they
of
are
this-
challenging.
They have
With
challenging
reference to bogus certificates, they say it's bogus certificates.
My lord, these are numbers of inquiry, my lord, we have, my lord, in the affidavit, we have, my lord, enclosed, which is go to show, my lord, how, my lord, the certificates have been granted. Madhuri Patil was a case, my lord, where there was no inquiry. So therefore, my lord, the subsequent judgment, my lord, it has been made clear that, my lord, wherever the rules or the regulation, etc. are operating, in that case, the direction of the Madhuri Patil case would not be applicable. Now, under this regulation, my lord, specific provisions have been made how inquiry is to be made, and then any person if agree where to appeal be filed. All these things are there, my lord.
Which page is the guidelines?
My 187.
And where is the inquiry report?
In my affidavit, I have, my lord, given, my lord, 2 inquiry reports. And my lord, one of the respondent, the police officer, he has also filed an affidavit. There also the one of the report.
Which page will we find it?
276. It will be, my lord, 276.
276.
Right. Don't have even my lord, locus standi to file, my lord. If it is, my lord, in the public interest, then my lord, PL can also be filed. All these things to be, my lord, adjudicated. I would therefore pray, my lord, hearing day may be fixed so that, my lord, matter can be, my lord.
First report is at page 276. The other report is at which page?
At page 286.
1?
286.
280.
That's 286.
Yes.
And yet another report, that is his complaint that was filed before the police. That is in the affidavit of the respondent number 14.
That would be in which page?
Page. Like 9 over
Yes, respond number 14,
240. 240 window.
240.
That's
No, this does not have a 240 affidavit, does not have it.
this has been filed by the respondent number 14. Yes, one and 14. It may be dated 4/12/2025.
1225. And Mr. Tabin, the authorities, they have shown, by these reports, it appears that in respect of 5 people, which is a report in page 221, and for 12 persons whose name appear in page 270, 276, we leave it for the time being. Page 286. This is with regard to 3 persons. So 5 plus 3, 8. We are omitting to read 276 right now, as this inquiry was conducted before the government issued the notification dated 1/8/2022, page 188. So this would not be an inquiry within the meaning of 1/8/2022. So how many persons are involved in this inquiry? The inquiry is being carried out for how many persons?
So page, because
First report is page 221.
actually pagination is
No,
different.
it's okay. This is an affidavit. That's why I'm referring to it. The first is an affidavit of respondent number 7 to 11.
Copy there.
Page lecture 1.
My note is referring to the record of proceedings dated 15/10/2024.
9/2/2013.
9. Yeah.
This is pertain to my client, 7 to 8.
No, that's why we are saying, you see, this is affidavit of respondent number 7, 8, 9, 10, and 11.
Yes.
Their annexure 1 is annexed. This inquiry was 2013. So that is also before the act. The second, what you call inquiry report referred to is at page 276. This
7/2/26.
This is
Very neat. Yeah.
7 to 26.
Annexure 2 is recent.
This is in the affidavit of respondent number 17 to 26. Now, this is also an inquiry preceding the notification. So this also goes.
15/10/2024, madam.
No, no. This affidavit was filed on 26/3/2026 by respondent number 7 to 26.
Yes,
Here, they have annexed annexure 1, the inquiry report.
yes.
This inquiry report is of 2008. So
Yes,
this,
2008.
so this goes also because it precedes the notification. Now we come to page 286 of the same affidavit. After the first inquiry, there is a second inquiry report, forwarding of record of proceedings.
Yes,
This is dated 24/10/24. This inquiry appears to be after the notification, and this refers to only 3 persons.
they are, my lord, in fact, the children of one of the persons that was.
No, we are not on facts right now.
Yes.
I am trying to understand because if we have to
These two
hear it,
reports
we
are
must
connected.
understand. Now, you see only this report is there. So under the notification, this has to be, the appeal can be filed.
Right.
And if there is no other report, then how does the government desire this court to proceed? It will be a pure question of disputed questions of fact.
Exactly, my lord.
Lordship, I'm sorry, this particular affidavit is not shared with me, Lordship, by the private respondent. Apart from that, Lordship, from Sejata, the department is the nodal department, Lordship. And that affidavit is yet to come from them, Lordship.
But nobody is interested, you know. Nobody is interested. We could have adjourned the matter, but if it is, since it relates to the issue of caste certificates and that too in this state, we desire that at least we can understand something so that we can have a preclude of what would be coming. So if that be so, then the issue of maintainability raised is a good starting point for the court to start. If there's no, despite complaints, if there's the authorities are not acting, they are violating this notification of 1st August 2022. So please tell us, what should we do when the inaction on part of the government is brought to the notice of the court? We take over the administration.
So, Lordship, last chance may be given, Lordship.
No, not last chance. You must have a, you see, when you proceed in the government and do the good governance, you must have a plan. If there's a complaint with regard to caste certificates and you are not taking no action, then why have this state protection of being a, what do you call, a protected state? You get all the constitutional benefit. Why?
As per that, when complaint is lodged before the committee, Lordship, whether the action has been taken or not, Lordship, that instruction, Lordship, we have not received. Action might have been taken or might not have been, Lordship.
No, the authorities, they are aware of this writ petition. If they are not taking any action, why should we spend our time here?
My difficulty is, Lordship, I have not received the instruction from the concerned department.
They are not ready to give it to you. You see, we can wake a person who is asleep. But if a person is asleep with eyes wide open, they don't want to work. They still get the salary. in your government. You don't take any action against them. And every time we have to request people to give us paravise comments to you and then file an affidavit as if the court is the only having the business of being concerned. Let the inquiry continue for next 10 years. We send it back to the authorities. Let them do the inquiry.
My lord. May I
So
pray,
the
my lord?
only other
Please,
alternative
my
would
lord.
be, Mr. Tapin, the only other alternative would be to give few tables and chairs outside our corridor and give them adequate space for the officers to come here and work from 10 to 5, clear files, show us the affidavits and then go back.
So with observation loss is a last chance also.
Government has created Directorate of Litigation. Director of Litigation. The joint director, joint secretary of the law department is the director, designated director, the director of litigation. But no control, nothing, no monitoring. All this filing of affidavit and it will be at least be monitored by that director. For years together also they don't file affidavit.
No,
And in some cases within 1 week also they file.
If officers in the state are not aggrieved by issuance of caste certificates, then why blame others? They are encouraging lawlessness.
Wonder once the matter is heard, as far as my client is concerned and the client 16 to 20, 17 to 26, we will show, my lord, that we are bona fide to Mompas.
No, that's okay, but you see, then we are taking over the administration.
As
As per the notification, it should be the appropriate authority to do it.
But because of the government's, my lord, lapse, my lord, we should not be made to suffer. We
Yeah.
have, because these things come up each and every time, my lord.
Yes.
From the report as well as various judgments of our own High Court as well as will show we are entitled to be granted custody.
We will put them to notice in a negative way. We say that if the
May I also make a submission if your lordship permits me? I appear for the petition.
Yes.
Let's, may I? Let's this present matter, as your lordships is also rightly observing, is a matter of great concern, not just for a borderline state like Arunachal, which is bordering China and Myanmar, and your lordships, and especially the government is perfectly aware of what situation our country is facing vis-a-vis Myanmar and Arunachal. As late as early as, or rather as recently as 1.5 months ago, certain people were arrested trying to smuggle arms to India from Myanmar, and they were arrested throughout the country. China, your lordships, is trying to create discontent in borderline areas, especially Arunachal.
Unless those are pleaded, we may not like to hear it. It would be more of a political statement than a
it's not
address to the court based on brief.
I am taking a cue from what was falling from your lordship's mouth. This is Arunachal. So I will stop it at there. Now I'll come to the merits of the case which we have filed. The Madhavi Patil case. Directions were passed by Honorable Apex Court because of a very, very alarming situation across the country, more so in borderline states, especially Arunachal, your lordships, and other borderline states. Now, these guidelines, it is not will of any authority, or dare I say any of the courts also, to refuse to follow Madhavi Patil's directions. And I have requested my learned friend, there is another judgment which I am referring to, which is Priya Gupta's. What is the effect of not?
Those will not apply once the state has their own mechanism.
No, that mechanism. Therefore, I am submitting, Milords. There is a reason for which I am, Milords, raising this issue of direct contempt in the face of Supreme Court's directions.
because it is not there. If there is a legislative intent, then we can challenge it.
No, you see, I'm sorry. You see, are we hearing a contempt of orders of the Supreme Court
No,
here?
I am just not the serious.
No, please stick to your brief. That will be more
I
beneficial.
am sticking to my brief that the government authorities are deliberately, your lordships, they are deliberately turning a blind eye. And this is the seriousness, because this petition is now pending for a very long time. They are even opposing. And who is the beneficiary? People who are other respondents. It is very easy for the government to say that we are not able to do this, and lordships is saying so much. I don't want to say anything more. I am only at this stage also only restricting myself, subject to your lordship's pleasure, that two things I want to express at this stage. This case may be decided whichever way your lordship feels as soon as possible. Second, my lords, as your lordships were saying, let us give them a negative notice. There are certain interim prayers. Nobody should have any objection to these interim prayers. Your lordships in the last order has also observed so. Not in so many words, but the prayers are what? Just implement the provisions of Madhavi Patil. What is the difficulty which the government is facing? And they have a good reason for that. I'm sure they will have a good reason for not implementing the procedure laid down by the apex court. And therefore, I was raising the contempt issue. My lords can suo moto also issue contempt, because this is a duty of this honorable court also to get the law laid down by the apex court implemented by all authorities. In that context, I was raising Priya Gupta's case. In the directions in Priya Gupta are crystal clear. It is duty. There cannot be an escape route for anyone. And since it has come to the notice of the petitioner, he has done his best to approach the honorable court after approaching the authorities. Now,
just for example, we'll ask you just a question. You come to paragraph 11 of your writ petition.
My lords.
It's just a random question. Come to page 11, para 11 of your writ petition.
My lords.
You're there?
My lords, I am.
Now, here you allege that private respondent number 27 is also an offspring of a Tibetan refugee so-and-so. Correct?
My lords.
This is verified in your affidavit as matters of record. Now, what is there in record to show that he is a Tibetan refugee?
There are, again, I will be traveling to issues which, what is my prayer, if your lordship would permit me to answer it like this?
No, not that. You see, there's a reason for that. There's a reason for it.
I understand that, lords.
You see, you see, there's a person A.
My lords.
The person Z alleges that he is an illegitimate son of B.
Yes, my lords.
Correct.
Yes.
Now, is it possible for the court to make a determination?
Therefore, I was taking my lords.
It's a disputed question of fact.
If
he's a Tibetan refugee or not, because you're making an allegation against a person disowning his nationality.
These are examples which I am quoting to my lords, highlight the main issue for which I have made certain prayers. That would be my lord's response to the query my lord is putting me to. My duty, therefore I have raised this issue of the duty of a private citizen. He has done his best. Maybe he is punching beyond his weight, but he is concerned about the situation. He is doing his best. Now there is a situation which is presently erupting. If this petition has been not delayed by deliberate attempts by the respondents, things could have not reached this far. Plus, that is as my lord is also saying, they are pretending to be sleeping. They are not sleeping.
No, but you see, you are making a roving inquiry against any person. Now today you can accuse thousands of persons saying that they are illegitimate children, they are X, Y, and they belong to this tribe, that tribe. Will the inquiry follow that complaints?
I am only asking for implementation. That's my sum and substance of the main prayer, that please follow the directions of the Supreme Court. Everything else is subordinate to the Supreme Court. That is my main prayer, my lords. The inquiries have not been conducted in a proper manner as directed by the Supreme Court. That's my main theme of filing this petition before my lords. And who should have objection to that? Therefore, I was trying to read to my lord Priya Gupta's case because it makes
No, even
things-
even the court will have objections. Why would they make an inquiry against the legitimacy of a person when that's not the?
my lord is only directing them to conduct an inquiry as per Supreme Court.
But
not
why? Why?
Because
somebody alleges that he's not the son of B, and we start making an inquiry.
no, it is not just somebody making an allegation. If your lordships would let us travel to the realm of the criminal law for a moment, if your lordship permits me. What is an
This is
FIR?
not a criminal. It is
No,
not
no,
a criminal
I'm
case
just-
at all.
yes, I'm-
It has
this-
civil
this is-
consequences. Citizenship is always a civil consequences. Under
Yes,
no
my
law
lords.
of the country, issue of citizenship is dealt with in a criminal manner. What is prescribed is that if he is a foreigner, he just is given a 6 month sentence or a particular sentence for
But-
being illegally entering into the country. But the consequences are civil.
Citizenship Act, Section 8, probably I remember correctly, 8A, the onus shifts the moment there is a complaint on the person. It's a very strict law, which is being challenged at the level of
That is-
FXO, but
that shifts under Section 9 of the Foreigners Act.
probably 8 or 9, yes,
9 of the Foreigners Act.
my lords.
That shifts the burden.
So therefore, citizenship, and that too in states like borderline states, has to be, and I'm not on citizenship at all. I am on caste certificate. Caste certificate is something which has been granted by the constitution to certain groups of people, not
No,
to.
we are taking up this. We have taken up this because now you say that he is a Tibetan refugee. That means a citizen of not India but Tibetan refugee.
Can I, at the cost of repetition, say if of inquiry, if things were proceeding as per Madhvi Patil's case, this petition would not have arisen. Now, your lordships is yourself, if your lordship, I can give a comparison to the notification and the guidelines of the Supreme Court. They are in the teeth of the Supreme Court directions. That is not disputed. That is our main, on the theoretical side, this is our main concern. And as a result, and as an offshoot of this notification, and even before that, when proper procedure was not being followed, the result is what is happening in the states like this. And this is not just happening in Arunachal, my lords, it is happening in other states also. So, but all I'm saying, my lords, once again, can I draw your lordship's attention towards the interim prayer?
No, you forget about the interim prayer. You come to page 48, that is your complaint. In 48, 49, you don't even give your address. You just disclose a mobile number and then say that this is the complaint. A requirement of complaint is that you must identify yourself. Your own identification is hidden. And we are making an inquiry on the basis of your complaint.
Police.
We find it very strange.
That bridge, I think we've already crossed. Police is in touch with me. I have made FIRs, I have met the police officials a number of times. My lords, I have been attacked.
That we don't know, but we are entertaining a complaint without which does not have an address.
If your lordship would have page 48, first paragraph, Shri Pasang Tesing, son of Shri Lekhi Pushto, permanent resident of village Jankar, house number E12, EO Kitpi, PS Tawang district. This is page 48 of my petition. I have given my details, but in any case, I was, police and authorities are in direct touch with me now. And my lords, I have been attacked. I have requested the trial court because in other matters to provide me security. I am not bothering my lords for that because that will complicate the issues. I have been shot at, I have been attacked. All these things I am not even bringing up in this petition. So I am taking a great risk for the larger public interest, my lords, on my person and my family also.
Yes, Mr. Tapin, how much time you need for the instructions to come? Otherwise,
my lord, actually, the Sejeta, the department was is being represented by extending counsel.
Yeah.
2 weeks time maybe.
2 weeks time.
Yes, ma'am.
If you are not doing it, then you will have to call your officers here.
But, my lords, may I just submit that if there is any objection from the government side to our interim prayers, that may be also inquired from them, lords, because that's a very.
But that's all. That they'll take care of it now since the department has appeared.
Plus, that they unfortunately not. Therefore, I am troubling my lords. Even now,
It's okay,
they are
yeah.
not.
Yeah.
Plus, at least something may be indicated in the order so that there is some urgency which creeps into the minds of the authorities that people who are responsible for implementing these guidelines. At least a few words that would actually this will proceed to a resolution. Otherwise, if no order is passed, and I can read orders after orders of my lords
Okay.
only. They are
What is your name?
Mahmood Pracha, my lords.
Okay. Mr. MD Mohammed Pacha, Learned Counsel for the petitioners. I just record the presence of everyone. Please give a slip. We'll record all your presence for so and so. For Mr. Pracha, please say it appears through video conferencing, and Mr. PJ Saikia, Senior Counsel, assisted by Mr. P. Borle, Counsel for the respondent number 17 to 26.
26,
Video conferencing. Pardon me?
17 to 26, your lordship.
17 to 26.
Lordship.
Yes, that's what. Next para.
I'll be waiting for 7 to 11.
I'll just give a step. We'll record everyone's presence. Since they are from video conferencing, we just recorded the name. Otherwise, we will not get their names. On a perusal of the various affidavits filed in the matter, it is observed that the inquiry report, which is appended to objection by respondent numbers 7 to 11, that the said inquiry was conducted, that the said inquiry report is dated 9/2/2013. So the inquiry report appended to the affidavit filed by respondent number 17 to 26
Another
is dated 7/7/2008. Another inquiry report appended to the said affidavit is inquiry report is dated 15/10/2024. Post of therefore, comma. Only the report dated 24/10/2024 is found to be conducted after the issuance of the notification, government notification dated 1/8/2022. Next para. The petitioners, the petitioners have alleged several persons named in their petition were not entitled to the caste certificates issued
Stop. There's nothing on record to show that the state government has made any inquiry as is envisaged by the said notification, and nor the state authorities have dropped any such inquiry against any persons against whom complaint is made by holding them to be duly entitled to issuance of such caste certificates. Therefore, comma, the only presumption that the court can draw at this stage is that the respondents in the Department of Social Justice, Empowerment and Tribal Affairs and the authorities nominated to make inquiry by notification dated 1/8/2022 are not performing their assigned work in terms of the notification dated 1/8/2022. Next para. In this case, the private respondents have all raised the issue of maintainability as disputed questions of fact arise for determination by this court. Next para, accordingly, comma, the standing for accordingly the Department of Social Justice and Empowerment and Tribal Affairs comma, the commissioner within bracket political bracket close chairman scrutiny committee. First is secretary department is respond number 2 and the commissioner political is number 3. Put to notice to file their affidavits so as to inform the court about the status of inquiry, comma, if any, against persons against whom the complaints were made by the petitioners. Stop. The affidavit shall be filed by 27/2026 with copies emailed to the learned counsel for the
27
petitioners. Your email address is available here. Somebody will note it down.
I will just type it and share it to us. In the
Yes.
box.
Please share your email address so that it can be done. Or you have a local counsel here?
Yes, Mr. Tapin Tapak is there. But I will share my.
Okay. No, it's okay. If Mr. Tapak is there, then he'll get it. With advance copy to the learned counsel for the petitioner. Next para. Place the matter for consideration of, for further consideration of the matter as well as on the prayer for interim relief on 24/7/2026. So we are giving you more than required time. Do it in the meantime.
Including the question of maintainability and the locus.
Okay. As well as the issue of maintainability and the locus standi of the
petitioners. Locus
but I-
standi, we can
I
determine
will
right
pay-
now. Locus standi, you see, a person who is making an allegation, he has a locus standi. It is in the interest of the state.
My lord, I'll show, my lord, my lord, had that been public interested person, my lord, the PIL could have been filed, my lord. He is not even for the job
No.
against
Why?
which
Why
we have been
somebody will not
appointed.
like to file on the PIL? He is paying court fees and coming to court. He doesn't have to show his locus standi then.
In PIL also, my lord, his bona fide, my lord, he has to
In
swear
bona, if,
affidavit that in
those
case
bona fide
default,
can
my
be
lord, he has to
challenged in
pay.
the, no, Mr. Sagar, bona fide can be challenged when it's a PIL. When he has paid court fees and then he has come, you can't challenge his bona fide.
Yes, man. Therefore, the format itself contains my lord, various clauses that he'll even my lord, pay the cost, my lord, 50,000. my lord. So all those clauses are so that's the shortcut method has been done here.
No,
Who
no,
are they,
that-
my lord, just my lord, in 2025 filing
You, Mr.
for the
Sagar, it's not
jobs.
open to you to say how he will come to court.
No, we
He
are
has come to court.
saying so. We are saying that they don't have the locus standi. They are not belonging to the Monpa tribe as such.
May not be, but
The
the interest
person
of the state is
affected.
there. Interest of the state is there. Why here A cannot be interested in the affairs of the state?
Lots will decide that. That's what my submission is. So the question of maintainability and the locus that may be kept open.
Locus standi, we are not inclined. Locus standi, we are, but yes, mentality will be there.
There are different tribes. It is only supposing a Mompa. I from East Siang district cannot be expected to know who is a bona fide citizen there. These are issues, man.
We understand that. But can a person be questioned when he's paying the court fees and then asking that?
Provided, my lord, he has brought something on
You see,
record.
if he's making a false allegation, let us say somebody makes a false allegation, then that A is not the A is not the son of B. What would be the remedy? It only is a civil remedy. You'll have to file a suit for compensation.
What we are praying, my lord, everything your lordship will consider. What I am thinking is, my lord will leave everything open, including the.
No, we are leaving it open. But
So the question are because.
We'll leave a scope for formally
On what basis, my
May I
lord, he has
just-
come to know?
Sorry, my learned senior is saying something. I'll wait for him.
Obliged, my lord, on the next day,
okay, locus standi, we are not saying, but this mentality, yes.
Yes,
They,
Well,
as my lord
yes, sir.
also was indicating, they have already filed a defamation suit against me. So that is their remedy. They should take it. Maybe I'll prove them wrong there also. And the thing is, my lords, the locus issue, my lords may kindly decide if your lordships at least something can be decided today if it is convenient to my lords. Otherwise, I'm entirely in my
No,
All right.
no. We are deciding it on the day, next
All right.
date.
All right.
So Lochivas kept the even question of locus also be open.
We are not saying anything. Mentality is open. You argue on that day.
There is already a
Lodge-
previous order.
Lodge.
There is an order, previous order, which limits
It's okay.
the ability aspect, which limits that. I have shown it to my lords
Okay.
again and again.
Obliged.
Locus is also covered in the maintainability.
Yes.
Obliged.
Item number 8.
Yes, Mr. Panging.
My lord, I am appearing for a petitioner, my lord.
Yes.
My lord, service upon respondent number 6 and 7 has been already completed, my lord. However, they are not appeared.
Mr. Tapin, you're in the matter?
This matter, I'm for this.
You're there. Now, if I understood it correctly, see your affidavit, page 17. So this page 17 is the relaxation, correct? And this was issued in the name of the governor by the chief secretary. Now, the withdrawal is by relaxation is by this page 23, 11th March 21. This is not in accordance with the this is because this was issued in the name of the governor.
Lordship, then another office member is there.
It is there.
This is only the Lordship communication to the Secretary Public Service Commission.
No, this page 23 is the relaxation. You are requested to extend the timeline window for submission of application, and then you say that this is a relaxation. Well, this is something which I have not been able to follow. That's why we are asking you. Okay, it's available. I have missed it out. Page 42 of the writ petition has that. Okay. Okay. I misread it. Okay. Both sides are represented as the readings are exchanged. There's the matter in the admission column on. We take it up after vacation. Yes. But before vacation, we have too many cases. 21, 22nd or 24th?
24.
Okay, 24th.
All right.
Item number 9.
But in this case, although respondent number 1, 2, and 3 has filed their affidavit,
Just a
give me one week's time to verify whether they.
just a moment.
So service complete
Transfer भी हो गया होगा.
हो गया.
Please done this.
Next week.
हाँ. Last time जो है आप लोग appear नहीं किया था ना, उसमें वही 6 का वो जो है सर्विस जो है अनसर्व्ड वापस आया बोल के.
6 का.
हाँ. स्टेप्स लेने के लिए फिर और पास क्या था.
Yes.
I may be given 1 week time because some officers might have been transferred. So I'll just, and also I have to take steps on respondent number 6.
Respondent number 6 has not been taken.
Yeah, Malad.
Okay. Mr. T. Patil, the counsel for the petitioner, placed for a week's time to obtain instructions as to the correct present address of respondent number 6. Stop.
And probably some officers has been transferred out. I have to make
This is
Okay, 5 also.
5 also.
Oh, 5 service complete. Okay, 5
Except
services
6,
complete.
my lord.
Only 6.
Only
Yes.
6.
Because that is
Accordingly,
come back answer.
Accordingly, it is provided that in the event the address of the respondent 6 has changed, comma, the petitioner is granted liberty to file an appropriate application to bring on record the correct postal address. Thereafter, orders will be passed for issuance of notice. You are appearing for respondent number
1, 2, 3.
1, 2, and 3.
Yes.
Okay. Please give your name. I am forgetful of names.
D. Riba.
Diloba. Okay. I'm sorry, I missed out names. Okay.
Obliged, Lordship.
Much
This
obliged.
transfer.
Please after?
After a week,
A week.
Mr. Patil, you wanted 1 week. You wanted 1 week.
Please after 1 week.
Okay.
1 week. Next Wednesday. No.
Okay. Make it
17. 17 June. Item number 10.
May I, Your Lordship? I'm appearing on behalf of conducting counsel at Tatar. He is currently out of station. Consequently, we are seeking time to file an affidavit in reply.
Both sides represented. On the prayer made by the counsel for the petitioner. 3 weeks time is granted to file affidavit in reply in the matter. First up. Next list on give a date after vacation.
After vacation. 29 July.
Okay.
Item number 12. PG construction.
Yes.
Yes, Lordship, the relief we were seeking in this petition, it has already been met. And government has already fulfilled all the prayers we were making in this petition. So this case is
okay.
Most probably, this case is infructuous, so it may be disposed.
Okay, give a name. The learned counsel for the petitioner, come upon instructions, has submitted that as the petitioner has got the desired relief, the matter has become infructuous. Mr. G. Tarak, learned standing counsel for the RWD, and Ms. P. Pangul, and a government advocate are present. Matter stands closed, having been rendered infructuous.
Much obliged.
Item number 13.
My Lord, I, on behalf of respondent number 1, 5, 6, and 8, my Lord, 3 weeks time may be allowed to file affidavit.
And you have not taken steps on respondent number 8.
On 8? 8 is, my Lord, represented by... representing.
You are appearing for
Yes,
8.
yes.
Okay. Okay, all sides are represented. You are making prayer on behalf of respondent by 8.
1, 5, 6, and 8.
1,
5, 6.
No. 5 is already struck off.
Oh, then 6, 6 and 8.
Okay. 1, 6, and 8.
Yes.
And who's appearing for 9 to 16?
Your Honor, I am appearing for 9 for 16, 9 to 16.
Okay. Okay, also as I represented, on behalf of the respondent numbers 1, 6, and 8, competent counsel pays for and is granted 3 weeks time to file affidavit in opposition in the matter. First off. Next one. In the event the affidavit is not filed, the matter would proceed on the basis of materials on record. List on. Give fixed date in this matter. After decision.
27 July. 27 July.
27.
Much of like.
Item number 14.
Yes.
Your Lordship. Lordship, it is a common matter, Your Lordship. In the repetition number 88 of 2026, Your Lordship. And the impute order 6 February 2026 was set aside by this honorable court on 8 April 2026.
This is covered. We have this judgment here.
Lordship, this text is a bit different. Lordship.
Facts are different.
Your Lordship, in the writ petition 88 of 2026, there also the petitioner was not given a prior notice and opportunity and so cause notice. And there is a violation of principle of natural justice.
Yes, what is your case then?
Your Lordship, in this case, the petitioner contested in election, and accordingly, certificate of election was issued and given.
Where is that act? This Arunachal Pradesh Local Authorities, the Defection Act, 2003.
the-
This at page 25 is already annexed, Lordship.
Yeah.
In the
25.
petition.
yes.
But in this act, is there a provision for issuance of show cause notice? Is there a provision for show cause notice in the act?
No, in the Arunachal Pradesh of local authorities for provision depiction act 2003, Your Lordship. However, there is in the section 6 there is in the act there is no provision, however, of issuing show cause notice. But Your Lordship, in the annexure 2, there is a disqualification order which is issued by the Mandal President in page number 18. And on the basis of that complaint only, the petitioner has been
But that is what even Schedule 10 to the Constitution of India says. There is no requirement of any issuance of show cause notice. If there is a complaint, it's a determination by the chairman. It's almost a
As
similar
per-
provision.
Your Lordship, as per the bylaws and constitutions of the rules 2012 of BJP also, and in the page number 8, I'm reading out the operative part. As per the Article 25, Clause 6 of Constitution and Rules of Bharatiya Janata Party 2012 states that no final decision for breach of discipline shall be taken against.
This issue, how does the Bharatiya Janata Party come here? How is it Bharatiya Janata Party or any other political party is relevant here?
Since the petitioner was contested from a BJP party.
No. Your disqualification is not under the BJP laws. It is or any other political party laws. It is under the Local Authorities Act.
Yes, Lordship, but my only contention is that since the principle of natural justice must prevail,
No, there's no question of natural justice. If the act says there is, it's not there. Even in Schedule 10, it is not there. You see Schedule 10 of the Constitution of India, it does not have a show cause notice. Give him a Constitution. Give him a book of Constitution.
Constitution.
Schedule 10, which is the defection law of the country, applicable in the parliament, doesn't have a show cause notice. It will be last. In this book, there are some commentaries. You will get that. It's the same book. You will get that at page 286. You see this in the
Yes.
Your Lordship, in my case, the petitioner was contested from BJP, and as well as he didn't merge to any other political party. He have filed his the member by the BJP, and as well as the certificate was also issued. And however, he was not nominated by the BJP, but at the time of scrutiny, at the time of nomination, his nomination was not rejected by the member secretary, and accordingly, certificate was issued. And then after, then after complaint was lodged before the deputy commissioner, that is annexure to page number 18, Your Lordship. That is on the 10 January. And stating that he have defected the party whip, which was issued on 3 January 2026. That is in the annexure 3 in page number 19. But in my case, Your Lordship, the petitioner not joined any political party. He contested from the BJP, and in the GPC also he contested in the GPC from the BJP party itself, the same party. That is the case. And accordingly, an expulsion order was issued on 10 January 2026. That is an annexure 4, Your Lordship, by the Mandal President, Hawaii, Chairman, Disciplinary Action Committee. And accordingly, the complaint was forwarded on 12 January 2026 by the member secretary to deputy commissioner. And accordingly, the impute order is issued on 6 February 2026. So in my case, there is no defection, since the petitioner is contested from the BJP, the member also, and as well as the Gram Panchayat chairperson also from the BJP itself, from the BJP party itself. And accordingly, certificate of election was issued. And Your Lordship, in the affidavit in opposition also, in the para 3, Your Lordship, the respondent not have not stated regarding the show cause notice. Since there was no prior notice, no show cause notice by the BJP also, by the this district. By the Mandal President Hawaii. Yes. Therefore, I was referring the party rules, Your Lordship, the operative part, the Article 25 of Clause 6 of Constitution Rules of Bharatiya Janata Party 2012 states that no final for breach of discipline shall be taken against any individual or unit without an opportunity being given to the individual, and unit concerned to explain and answer such charges are made against it or him or her. But in my case, the petitioner didn't join any political parties. He have elected from the BJP, and again in the GPC also he have contested from the same party. And Your Lordship, the certificate could have been disqualified at the relevant point of time by the member secretary, but the member secretary didn't rejected his nomination. And Your Lordship, in the Article 25 of Clause 5 also of the Bharatiya Janata Party of said that the disciplinary action committee must submit the report to the president not more than 15 days. And the state president shall take action on the recommendation of the disciplinary action committee within a week. If final order is not passed even after the prescribed time, the case will be referred to the immediate next morning of the state execution for decision. The state president will communicate the action taken into concerned person or unit within a month.
Yes.
And in the Article 25 of Clause 9 also, it says that any member contesting against official candidate of the party will be summarily expelled from the party by the state president or the All India president. But in my case, the expulsion was issued by the Mandal president. Therefore, Your Lordship, the impute order may set aside.
Yes, Mr. Tapin.
Lordship, in this particular constituency, it's 4 Kroma Gram Panchayat, Lordship. There are 4 members, Lordship.
Three.
And all of them were elected from the BJP ticket, Lordship. For the elections of the chairpersons, from among one has to be elected as a chairperson, Lordship. Election was fixed and then a whip was issued to them, Lordship, by the BJP, Lordship. Kindly come to page 57 of my affidavit, Lordship.
Yes.
Affidavit filed by respondent number 3. This is the whip issued by the Lordship Bharatiya Janata Party.
Can the temperature be brought up? It's very cold.
Bharatiya Janata Party, Lordship. And it was received by the present petitioner, read petitioner. Down below, Lordship, you'll find the receipt is there, Lordship. Binsa Chiba is the read petitioner, Lordship. By this whip, Lordship, particular direction has been given to all the Lordship Gram members to support or to vote the Lordship officially nominated candidates, Lordship, or chairperson, Lordship. And in the present case, Lordship, one Srimati Jateliang Chipui, she was, Lordship, officially nominated candidate for the chairpersons on behalf of the BJP, Lordship. All of them are BJP only, Lordship. Now, Lordship, in the election, what happened, Lordship? The petitioner himself, he has contested against the Lordship officially nominated candidate, Lordship. That's the facts, Lordship, which is not disputed, Lordship. And if Lordship see the act itself, Lordship, Act is at page 25 and relevant is section 3, Lordship.
Yes.
Subject to provisions of section 4, 5 and 6, a member belonging to any political party shall be disqualified for being a such member if he has voluntarily given up his membership of such political party, or if he votes or abstain from voting in or intentionally remain absent from any meeting of the Jilla Parishad or Anchal or Gram Panchayat contrary to any direction issued by the political party to which he belongs to, or any other so and so and so. His petitioner case will come under this particular Lordship. So he has gone against the Lordship directions given by the political party, that is the directions provided under the whip, and he has voted, contested against the officially nominated candidate lordship. Now, in this regard, lordship, complaint was lodged by the lordship district BJP, and that was to a member secretary lordship. And then it was forwarded to the concerned authority, just a deputy commissioner. And this fact was brought before the deputy commissioner that he has lordship contested against the officially nominated candidate for the chairperson. And admittedly, lordship, no opportunity of hearing was given to the present petitioner lordship. And under these circumstances, lordship, since it's admitted position lordship, so he has been disqualified from the Gram membership lordship. This is the facts lordship. Now,
he's referring to this judgment of WPC 49 of 2026. Here also.
Dear lordship, he has not, in petitioner dear lordship, he had not contested the election lordship against the officially nominated lordship. Here lordship, he has contested lordship, not only a voting against or not lordship, but he has contested lordship. Now, as lordship has pointed out, also, Act itself does not provide lordship the so-called notice has to be issued. But even then, my understanding is lordship, at least the opportunity of hearing should have been given lordship. But in the present case lordship, when it's admitted position, which is exception to the principle of natural justice lordship, I'd like to bring in the useless proposition.
Useless formality.
Yes, useless formality. And just I brought one judgment. Here is it came out of MC Mehta and then SL Kapoor, and this judgment of 2007, the Aligarh Muslim University versus Mansoor Ali Khan lordship. Here it says lordship, even after giving opportunity lordship, if the same conclusion is going to be lordship reached lordship, then lordship Article 226 lordship that useless direction would not be given. Here, paragraph 21 to 27 are relevant, but I'd like to read only 23 lordship. And here I have filed affidavit lordship that he had contested against the officially nominated, and that has not been denied or reverted by way of filing rejoinder lordship. And the paragraph 23 lordship. Here, SL Kapoor's case has also led on two exceptions, namely, if upon admitted or indisputable facts, only one conclusion was possible, then in such a case, the principle that breach of natural justice was in itself prejudice would not apply lordship. So this is the stand on behalf of the state lordship.
Yes, Mr. Bori. You are supporting Mr. Tapin, or you are supporting?
Yes, Lordship. I'm for respondent number 2, district president.
Yes, or you are supporting Mr. Tayang?
No. Yes.
You have a third stand. You have a third stand.
Yeah. Lordship, actually, there's no prayer against me in this writ petition. The prior person is this is disqualification. If Lordship may refer to the prayer. Disqualification order dated Hawaii 6 issued by the Deputy Commissioner Hawaii, and another is the
You are respondent number
2.
2. Okay.
So there's nothing against me. And regarding this I've issued party whip, and after preliminary inquiry, everything has been done. He was from the, he has acted against the party whip. This was. And since there is no prayer against me, then
Member, he's your good member. He has not prayed anything against you. Responsible to.
but he should have some discipline in the party discipline.
Your Lordship, in my case, since the nomination of the petitioner could have been rejected on that time, and the petitioner has never contested from other party, from the same party itself. Therefore, I'm not.
So it's okay. That's why you see he's a good member. You should reconsider.
Your Lordship, since I was not aware of the 10th schedule, so a time may be given.
No, that's not required. We just shown you because this happens in any anti-defection law. There's no provision for show cause notice. It's only for that purpose, nothing more.
I'll prepare next.
No, not after half an hour of argument. Heard Mr. K. Tayang, Learned Counsel for the petitioner. Also heard Mr. S. Tapil, Learned Senior Government Advocate, appearing for respondent number 1
and 3.
And Mr. U. Bori, Learned Counsel for respondent number 2. Next. In brief, the case of the petitioner is that he's elected Gram Panchayat member from numerical 4, Kromna, Kromna, Gram Panchayat, under Taimna, Taimna, Taimna constituency. Full stop. The said Gram Panchayat constitutes of 4 elected Gram Panchayat members, out of which 1 elected Gram Panchayat member would become the chairman of the Gram Panchayat. Correct? Chairman.
Correct. Chairperson.
Chairperson of the said Gram Panchayat. Full stop. The petitioner, who is the member of a particular political party, offered his candidature as the chairperson of the 4 Kromna Gram Panchayat. Stop. How, the Deputy Commissioner, Hawaii. You make it like Deputy Commissioner, Anjao District, Hawaii, HAWAI. by the impugned order dated 6/2/2026 declared the petitioner to be disqualified from the membership of the said Gram Panchayat by applying disqualification clause under the Arunachal Pradesh local authorities within bracket prohibition of defection bracket close act, 2003, read with clause within bracket small c this 3(1) B and C. Is it right? 3(1) B within bracket 3 within bracket numerical 1 within bracket small b and within bracket C. And the defection and the disqualification was ordered pursuant to powers under subsection 2 of subsection 6 of the said 2003 Act, read with section 4 of the Arunachal Pradesh local authorities within bracket prohibition of defection bracket closed. Again bracket amendment bracket closed Act, 2006. Stop. Next part. The learned counsel for the petitioner has submitted that the petitioner is the member of the said political party, and when he offered his candidature for the post of chairperson of the said Gram Panchayat, he did not act against the said political party, and his candidature was offered as a member of the said political party. Full stop. It is stated that the Mandal president of the concerned political party did not have any authority to issue any such any party whip or to initiate disciplinary action against the petitioner. Full stop. It is submitted that there was an inherent requirement of issuance of show cause notice to the petitioner before taking any drastic step of disqualification. First up, it is submitted that the constitution and rules of the said political party also envisaged granting of an opportunity to the concerned person of being heard before taking any action for any disciplinary action against the member of the said political party. So accordingly, by relying on the decision of this court in the case of RIMSO, RIMSO, Belai, BELLAI, and 2 others versus the Deputy Commissioner and 5 others, WPC 49 of 2026, decided on 8/4/2026. It is submitted that the
action taken against the petitioner without following the principles of natural justice by not issuance of prior show cause notice made the said impugn order dated six to 2026 liable to be set aside and quashed. Next paragraph. Par contra, the senior government advocate has submitted that as the respondent number 2, being the deputy commissioner, Punjab district, what is the name of the place? Punjab district, Hawaii. Was informed of the initiation of a disciplinary proceeding against the petitioner by the concerned political party for anti-party activities and for defection. By disobeying the party whip dated 3/1/2026 and the said authority having exercised its powers conferred under subsection 2 of section 6 of the said 2003 Act, held the petitioner to be disqualified from the membership of the Gram Panchayat concerned. And accordingly, it was ordered that the petitioner would cease to hold the office of the Gram Panchayat member. Full stop. Accordingly, it is submitted that on the facts of this case, as the issue of defection was raised, the decision of this court in the case of Ramso, RIMSO, BELLAI, and others, within bracket Supra, would have no application. Next paragraph. The learned counsel for respondent 2 has submitted that there is no relief claim against the respondent 2. However, supports the submissions made by the learned senior government advocate. Next paragraph. In this, do we have rules for the made under this 2003 Act? Do we have a rules?
Rules is not. Rule is not.
There is no rules.
No.
Thousand three. Rules नहीं इतना.
Kau makan ni.
Next paragraph. The next, the learned senior government advocate has submitted on a query of the court that no rules have been framed under the 2003 Act. Full stop. In the case of Rimso Bilai within bracket Supra, this court, the coordinate bench of this court had taken note of the difference that there is no specific provision in the 2003 Act to issue show cause notice or to provide personal hearing. So, however, this court was of the view that the principles of natural justice are ingrained in the realm of administrative and quasi-judicial matters.
Lordship also may take note of paragraph 3, Lordship, in this Belais case, Lordship. In this Rimso Belais case, Lordship, I may take note of paragraph 3 also, Lordship. How the facts are different, Lordship.
In this regard, the senior government advocate has referred to paragraph 3 of the said judgment, and it is submitted that as per the facts of the said case, which is distinguishable, 3 petitioners were elected from 11/2, 11/3, and 11/4 Gram Panchayat constituencies in the district of Anjao. Full stop. The petitioners therein had merged into the majority and had formed a new political party. And accordingly, it is submitted that if they formed a majority, then it would have been a different matter. However, it is submitted that in the present case in hand, despite the party whip, as the petitioner had offered his candidature, the issuance of a show cause notice would be an empty formality. Next paragraph. In this case, the petitioner is annexed to the petition of the party whip dated 3/1/2026. Full stop. The petition is also annexed to the petition and expulsion order of the concerned political parties, apostrophe as Mandal president. dated 10/1/2021. On account of breach of party discipline. So the petition is also annexed a copy of application for disqualification issued by the member secretary of the of 02 dash Chalongnam CHAGLONGAM Zilla Parishad constituency, by which an application dated 10/1/2026 was forwarded to the district election officer, Punjab district, Hawaii, for treating the petitioner to be covered by defection on his being found guilty of disobedience to the party whip. Next paragraph. Therefore, the facts of the present case is distinguishable from the facts of case of Ramso Bilai and two others. Stop. Next paragraph. Therefore, with all respect to the decision of this court in the case of Ramso Bilai within bracket Supra, this court had emphasized regarding the adherence to principles of natural justice. But in this case, the issuance of show cause to the petitioner would be an empty formality, as the concerned political party has moved the authorities for disqualification of the petitioner on account of disobedience to the party whip. And moreover, concerned political party has also expelled the petitioner from the party for anti-party activities, and specifically for disobeying the disobedience to the party whip. Next, therefore, comma, in respect to the present case of the petitioner, as there exists a party whip and disobedience of the party whip, the petitioner has been expelled from the concerned political party, who had moved the authorities for disqualification of the petitioner. So accordingly, the appealed order dated order number, page 24A, order number so and so, dated 6/2/2026, would require no interference of this court. So accordingly, this writ petition fails and this same is dismissed. Next paragraph, it is clarified that nothing contained in this order would mean that the ratio laid down in the case of names of Bilai and others within bracket Supra has been targeted by this order.
Your lordship, this the in the recent in the case of this Crimson Bilai, your lordship, the in the paragraph 8. In the paragraph 8, the adherence to principle of principles of natural justice as recognized by all civilized states is of supreme importance. When a quasi-judicial body embarks on determining disputes between the parties or any administrative action involving civil consequence is an issue, these principles are well settled. The first and foremost principle is what is commonly known as odi alteram.
We have taken note of that. We are not disagreeing with this principle, but in your case, we are invoking the principles of empty formality. We are not directing. We have in fact asserted that this is the correct principle, but we are invoking the doctrine of empty.
Pronouncement of judgment of item number 18.
The application is allowed and the arbitration appeal is rejected.
Item number 15.
Please, my lord, this is a transfer matter. Challenging the my lord transfer order dated 27 March 2023, whereby my lord I have been posted from Naharlagun to my lord B Puri. My lord, I am working as a cashier in the my lord office of the Oriental Insurance Company, my lord. So, my lord, this notice was issued on the first occasion, and this matter is come up for the second time, my lord. So, as per the previous order, my lord, this interim order is supposed to be considered today, my lord, on appearance of the respondent. So, my lord, these respondents are appearing, my lord. Therefore, I am insisting, praying for this honorable court to pass, my lord, interim, my lord. Operation of the impugn order be, my lord, state till the, my lord.
But you are in a transferable job.
My lord,
You
that
have to be transferred.
to that extent, my lord, I am admitted that all the jobs are, my lord, in transferable, my lord. But I have a my lord, the exceptional case that, my lord, my wife is alone here and my wife is working here in the Itanagar, my lord, in the PWD department, Naharlagun at the PWD department. And she is suffering from many ailments. And at this stage, she is alone. Therefore, if I will transfer, my lord, it will be very difficult for me. And at the same time, so far the transfer order is concerned, my lord, I have been transferred there to take the charge of, my lord, branch in charge. Whereas I have not up to date qualification to take the in charge of, my lord, this branch in charge. I'm in cashier, so my next post is the my lord, assistant senior. And assistant senior is the Peter post of that holding branch in charge. So my lord, branch in charge is very heavy duty, my lord, controlling the entire. And this has been made, my lord, without any financial benefit and my lord promotion. As if my lord is overburdened with me, my lord. Because next hierarchy to my post is I am in Peter post of assistant senior, my lord.
Senior assistant.
Senior assistant. So, my lord, what the respondent say, my lord?
Yes.
My lord, I have instruction to file affidavit in opposition.
How much time?
I need 2 weeks time, my lord. I'm filing affidavit in opposition.
Is pressing for the prayer for interim relief. You don't take coercive action against him till today, 2 weeks.
Yes, my lord. Yes.
Don't take coercive action against him.
Okay, my lord.
Mr. C. Modi, learned counsel for the petitioner.
For Oriental Insurance Company, my lord. Sole respondent.
Also heard Mr. For the counsel for respondents 1 and 2, who submits that he has received instructions to appear and prays for and is granted 2 weeks time to file affidavit in opposition as well as his wakalatnama. Stop. As it is projected that the where is the statement that you are not qualified to hold the post of branch manager? We did not find it. Where is the statement that you are?
My lord, exactly, my lord, that person has not been stated, my lord. But I am the cashier, my lord.
No, that's okay. Why not? Why even a qualified, what you call, otherwise a very capable peon cannot be made to be a branch manager. If an industry can be run by a person who is not educated, what is wrong in any other person joining as branch manager? Nowadays, what work does the insurance company have?
He has
Nothing.
been transferred, my lord, due to insufficient staff of the company. So,
No, correct. Nowadays, what work does a insurance company and all have? Nothing. What work do you have in your office as a cashier? Nothing. No cash comes. Everything is online. So you will have to request you to be terminated. There's no work for a cashier and therefore it can be expended. That the You've been in this branch for how many years? You have not said that also.
He has been working more than 10 years.
In the same branch.
Same branch.
Then you can't have a protection. There's another reason why you can't be given a protection.
Due to medical ground.
You see, page 6, you have made a mention of a disease at page 6. This shows that you are also unfaithful. Page 6, paragraph 3, at the end. About 6-7 lines from the end, after this said transfer order dated 27/3/26. Look at the disease you have made a mention. Are you aware why people may contract this disease?
No, man.
No.
Acute blood interaction disease, and therefore to comply the transfer order, it would be impossible for him to help. It does not permit. So, my lord,
It's not entitled you to a protection.
I'm taking constant medical treatment at the
You have
Niva
to,
hospital.
because
Man.
the disease of the disease, this disease is not an this is an acquired disease. You won't have if you are faithful to your partner.
And at the same time, my lord, I'm also taking the ground that my wife is my lord.
Then you see you're not getting it, because if you're more than 10 years in one place, you have to be transferred. You don't have a vested right. And once you make this statement of the nature of illness,
And para 6 also, my lord, reveal in page 8, my lord.
you can't have protection.
Otherwise, my lord, my grievances were ventilated in the form of my lord representation on 30 March 2026, and that has not been attended by the.
Page 16.
No, because you see, there are other reasons also. If you're 10 years, then we can't give you a protection. You'll have to join, and then we'll say that your joining will not be a bar for passing a final relief.
Once joined, my lord, this petition will be in process, and
No, no.
on the basis of my lord, this.
SL Abbas says so. SL Abbas says that one should join first and then represent for retaining.
And my retention application on 30 March has not been attended, my lord.
Not required.
His representation may be attended, my lord. So
Within a week, you dispose of a representative. Till then, you don't.
within 2 weeks, we'll dispose of this representation.
Okay. Next. Then consider the petitioner submitted that he has also submitted a representation dated 30/3/2026 against his transfer by showing cause. Accordingly, we direct the respondent number 2
I, the regional manager from our Oriental Insurance Company, dispose of the said presentation dated 30/3/2026 within bracket annexure Roman 2 within a period of 2 weeks from the date of the order and communicate the same to the petitioner. Till then, the respondents shall not take any coercive measure against the petitioner. So before that, you also say that the learned counsel for the respondents has submitted that as per his instructions, the petitioner has been employed in the same branch for last more than 10 years. And due to acute shortage of staff, the respondents have transferred the petitioner to his new place of posting. After that, this, okay. Give a date after 2 weeks.
30 30 June.
30 will be just last day. Just,
Then
will be very, okay, 30 is. Okay,
1st July.
30. Okay, 30. Okay.
30.
Okay.
All right.
Marvelous.
Pronouncement of judgment of item number 1.
The appeal is dismissed. Interlocutory application, if any, also stands dismissed.
Pronouncement of judgment item number 2.
आइए सर. Matter is dismissed. They've been notified.
Yes.
They've been notified.
This one, yes, yes.